Winston Finzi against Jamaican Redevelopment Foundation and others.
My Lord, good morning. My name is Anthony Gifford, and I appear for the appellant in this matter. I'm assisted by my learned friend, Mrs. Terry Ann Gaia-Tolan, and my learned friend, Miss Aisha Thomas. For the respondents, my learned friends, Mrs. Fraser Magnus Phillips, King's Counsel, Mr. Maurice Manning, King's Counsel, appear instructed by Myers Fletcher and Gordon.
Yes.
Well, may I start by thanking you for the courtesy that you extended of enabling me to speak from a seated position, and indeed your staff too have been extremely welcoming. I can give a tick on the highest rung for the Supreme Court's ability to deal with disability. I will try to keep my voice clear. If there's anything I'm missing because of the weakness of my voice, I apologize. I haven't done. I would like to introduce this appeal by quoting a passage from the learned judge, Mr. Justice Lang, which gives you a background and gives you some information about Jamaica at this time. It's in the key documents bundle. It starts at page 135 in the electronic bundles. And the passage I'm going to go to is paragraph 7, which is to be found on page 138. EF, page 138. And what the judge said is interesting. It is a matter of historical record that the 1990s in Jamaica was characterized by a period of extremely high interest rates. The reasons for this will be debated for years to come. But what is undeniable is that this high interest rate regime wreaked havoc on and or led to the financial ruin of a number of individuals and businesses who became debtors and who are unable to service their debts. There was also what has been termed a financial meltdown of various financial institutions of various sizes. And in 1997, the government of Jamaica established the Financial Sector Adjustment Company, FinSAC, whose mandate was to restore stability to the financial sector. In pursuance of this mandate, FinSAC acquired a number of non-performing loans, debts, liabilities, and securities, which belonged to those financial institutions, which had accepted the intervention and the assistance of FinSAC. This case has its genesis in that era and has a close connection to the financial arrangements born of what is now commonly known as the FinSAC area. So I thought it'd be useful to know what is etched in the minds of all Jamaicans, that is to say the financial crisis which struck the country in the 1990s. The claim from which this appeal emerges was begun in 2017. May I ask you to look at the claim itself, which is at page
19.
19?
19.
Page?
19. 19 officer.
Page 135 in the electronic bundle.
That's the judgment of claim.
And, the
The particulars of
the particulars of claim are at page 19. Page 19. And what the claim states, the claim form states is this: the claimant, Winston Finzi, claims against the defendants Jamaican Redevelopment Foundation, a company incorporated in the state of Texas, with principal offices and the address is given in Texas, and is registered in Jamaica as a overseas company, with its address in Jamaica being as given. And together with them, Jonathan Goodman, Janet Farrow, David Alexander, Jason Rudd, and Nadia Sinclair. And over the page, there are two further defendants.
I think the particulars of claim begin on page 26.
That is right, Madam.
The claim form billing.
And may I indicate that of those 8 original defendants, the 4th, 5th, and 6th were observed.
The second, third, and fourth were not.
The 2nd, 3rd, and 4th were not served. They play no part in the process. The other defendants were served, and they applied for the claim to be struck out as an abuse of process. But when the matter got to the Court of Appeal, and after the decision of the Court of Appeal, when there was a question of appealing for leave to your lordships, we did not bring in the 7th and 8th defendant. And that was a conscious decision, and underlying all of this case is certainly my clear understanding, it's been repeated so many times, that counsel alleging fraud must be on solid grounds, must not do so lightly or frivolously.
Well, absolutely, Lord Gifford, and reading this pleading, it's liberally sprinkled with allegations of fraud, perjury, dishonesty. I couldn't find anywhere in it any particulars which set out any matters which could properly support an allegation of dishonesty. If you can show me somewhere in the pleading, I'd be grateful.
The particulars are there, and we'll come to them. But I agree, and that there are adjectives and nouns used in the pleadings, which I would not have used, but they serve to underline what we are going to say, and we will see if your lordship, we're going to persuade your lordship, we're going to say is a very serious course of enrichment and dishonesty.
Well, you accuse Mr. Goodman of making a perjured affidavit, but you don't set out any grounds, or not you, whoever the pleader was, on which it might be inferred that he's made any statement which he didn't honestly believe.
What he said was that the foundation was a successor to had all the rights to enforce a debt over a property called Appellant. In fact, they had no such rights.
Well, that doesn't show that he didn't believe it, or that he was saying something deliberately false.
In fact, when you think of the fact that they received for themselves in charges when Avalon was sold to the tune of some $4 million United States dollars, there are many ways of showing that on the face of it, without any explanation, these actions in which the JRF took onto themselves privileges and rights which they did not have. They were not given the right to deal with the Avalon debt. And there are many other areas where they managed to suck in huge levels of interest. And certainly the case that we put forward is that there is a very strong chance that the court would agree that fraud was found. And that when one looks at the number of occasions, and both I and my learned friend are going to deal with them, where the foundation secured benefits for itself, enriched itself by obtaining rights which it didn't, by exercising rights which it didn't exist, it didn't have. And that was perhaps most clearly exemplified by the exercise of a power of sale in the Avalon property, which secured a purchase of some 6 million, of which 4 million went into JRF's pockets. So we
understand, Lord Gifford, that the 2017 action makes wide-ranging allegations of fraud. The question is whether it's open to you to make those allegations.
I'm sorry? I didn't hear, Lordship.
We appreciate that the 2017 action makes wide-ranging allegations of fraud.
Yes.
And dishonest conduct. The question is whether it's open to you to rely on those pleas. And I think we do need to focus on that particular question.
Well, I think I'd broken off after saying that Mr. Alan Wood and the fellow of Livingston Executive were no longer part of the action, and the judgment striking out the claim stands so far as they're concerned. The three respondents before you today are essentially one entity, the Jamaica JRF. I shall call them JRF because the other respondents are just
they're employees.
Agents,
they're employees of
officers.
JRF.
Yes.
Yes, we understand that. Thank you.
And you will, I don't think I need read all the details of the way the proceedings went. JRF applied to strike out the claim as being an abusive process. They relied, of course, on the principle of finality in the case of Henderson and Henderson. The learned judge applied the law as he thought it was, particularly in the case of Takar, which at that time had been a case in the Court of Appeal of England. And he found that the appellants ought to have exercised reasonable diligence before they, if they had any information concerned with fraud.
Well, Takar is a case, as I read it, Lord Gifford, about whether it's necessary to exercise reasonable diligence in discovering evidence.
That is right. And I don't know your Lordship is very familiar with it. But what is interesting about this case is that when it was heard before the Supreme Court and the Court of Appeal, Takar had been decided by the Court of Appeal on the basis that reasonable diligence was necessary. Your Lordship was one of the seven-man court, seven-judge court, disapproved of the Court of Appeal, overruled its decision, and found that reasonable diligence was not an ingredient, a necessity for a litigant alleging fraud who wants to, as it were, reopen the case. The development of the authorities is interesting because on the one hand you have the principle of finality, and on the other hand the principle of honesty, and the rule of law. And we are now reached a position where the Supreme Court has said that if a litigant wishes to allege fraud, he is not prevented from doing so by any doctrine of reasonable diligence. However, there are some particular qualifications which the court put, which I shall examine. But may I just go to how the courts dealt with it in Jamaica, and we'll see that in fact they made serious errors. Mr. Justice Lang gave a very thorough judgment, which is to be found at page 135.
At page?
135.
Yes.
And I'm going to take it fairly quickly because I don't think there's any real dissent as to what the law now is. But when the matter came before Justice Lang, at paragraph 59, he considered the Takar case. But he considered it, of course, a Court of Appeal decision, which it then was. And of high persuasive authority. And what he said was, at 59, and I go from on the page 161, 6 lines down. As a consequence, this court does not have a binding Privy Council judgment in support of the due diligence condition. Accordingly, in my view, as a matter of precedent, it is open to this court to find that the current English position is persuasive, and I do so find. I adopt the view of Lord Justice Patton that the English position, as found in the case of Takar, has been settled in respect to the existence of the due diligence condition. I adopt his view that the current English approach represents the balance struck by the English authorities between two policy considerations which are in play. Firstly, finality of litigation. Secondly, fraud being a thing apart which unravels all. The English approach, in my view, evidences a manifestly pragmatic compromise, and it is only fair and prudent that this course adopts it. So there you have...
Well, that, as it turns out, was wrong.
That's gone.
That's wrong, and the Court of Appeal decision was delivered before the decision of the Supreme Court in Takar. By the time the application came on before the Court of Appeal in Jamaica to seek permission to appeal to the Privy Council, the decision in Takar had been handed.
Yes, right,
and Miss Justice Williams, in her judgment, which is the judgment of the court, paragraph 44, specifically addresses the point. And that's on page 242. And what she is saying is that the letter of August 2011 contained the information on which the allegations of fraud and dishonesty are now based. She says there was no new material, but rather the same material already available to the applicant being used to form the foundation of another claim.
My Lord, our submission was that she was wrong in her application of the Takar decision in that sentence. What Takar says is that although there is no requirement for reasonable diligence, if you make a conscious decision, if you know about the fraud, you make a conscious decision not to base a claim on it at the time of the first proceedings. You can't come back years later and rely on the fraud because you knew about it and you made a conscious decision not to avail yourself of it. That was not the case with Mr. Finzi.
Well, why wasn't it the case with Mr. Finzi?
All Mr. Finzi was told in the disclosure was that what Mr. Finzi was told in the disclosure was that the debts which JRF took over did not include the Avalon property, and therefore what is interesting about the disclosure that was made was that it didn't necessarily involve fraud. It was information that these properties had been assigned to JRF, and this property had not, because only these had been assigned. That does not automatically mean fraud.
So what is there in addition in the particulars of claim that is new that takes this from a mistake or whatever into fraud? What is the additional factor that Mr. Finzi now relies on if you say that the information he got from FinSac in August 2011 or July 2011 was not evidence of fraud?
What happened after that was that the claim of JRF against Mr. Finzi proceeded, and he reached a settlement, which is endorsed on Council's brief, a lengthy settlement. He did that clearly under pressure from the circumstances, but there's nothing to indicate that he had formed a view in this very complicated set of facts that fraud had taken place.
Well, what has changed his mind since? What's enabled him to now realise that it was in fact fraudulent as opposed to just wrong, the claim?
Well, for a start, the sale of the Avalon property.
Well, that was just done pursuant to the
consent agreement.
Consent agreement.
That's right.
So that doesn't show that the information he was given was dishonest. What has caused him to realise now, as he says, that the material provided by Mr. Campbell was evidence of fraud as opposed to just evidence of inaccuracy in the claim that was being made against him?
My Lord, one should not accuse someone of fraud without very good grounds. The pure knowledge that Avalon was not a JRF property certainly put Mr. Finzi on inquiry. You could say that if the reasonable diligence condition still was part of the law, then Mr. Justice Lang and the Court of Appeal were right in applying it to that situation. But the picture had moved on. JRF had reaped a lot of benefit from the Avalon property, and they had never, in any sense, accepted they were wrong. So that you have to you look at the whole the whole picture. And he could not, he could not and did not, because you could see his motivation. I think we've quoted it when he wrote to the Finzi under the Access to Information Act. But he wanted to know what was going on. He wanted more information. He wanted to put his lawyers in the picture. And it took some time. You could say it could have been quicker, but it took some time to unravel the whole set of circumstances.
Well, what did he discover between 2011 and 2017 which made any difference to his claim? What new information, if any, did he discover after the letter in response to the Freedom of Information Act case, which he didn't think at the time provided grounds to allege fraud, which added to that and then did give him think that he had grounds to allege fraud? Was there any single piece of additional information that he obtained that was relevant?
It was a knowledge that despite the fact he didn't own it, JRF went on to enforce the Appellant security as if it was theirs.
But he'd agreed to that in a settlement.
It is a feature of these cases where fraud has been unravelled that litigants accept the state of affairs, which they are, like Mrs. Takar, for instance, and it's only when the full extent of the dishonesty reveals itself that they're able to say, and their lawyers are able to say, yes, we reached a point where we can make a claim for fraud.
Well,
I don't think that point had been reached purely by the.
What was it that caused that realization?
The enrichment, the huge enrichment that JRF had made on security, which is not theirs.
They didn't, in fact, have the debt. If he owed them the debt, then they weren't enriched by selling the property, which was security, they thought, for the debt, and repaying themselves.
You would have to raise that in court.
The enrichment doesn't show that they didn't believe the claim that they were making.
And when you have this company, this is a debt collecting company, it's not a bank, it's a debt collecting company. When you see this debt collecting company, sell these valuable properties, extremely valuable properties, and getting money, because they exist to get money from enforcing the securities. And when Rio Hotels Limited bought Avalon for $7 million US, JRF must have been cock-a-hoop, because they got a whole heap of money from Rio as the greater part of the proceeds of sale, when in fact it wasn't theirs to dispose of. And
Lord Gifford, as I understand it, you're saying that there was insufficient material in August of 2011 to justify a plea of fraud, and something happened thereafter which justified it. And at the moment I'm mystified as to what that event was.
It was the sale of Avalon and one of the others.
It's said to be the sale of the property.
To which he agreed.
It still reminds me that he went on asking questions, and he asked for an account of the proceeds of sale, and he got it in due course, and that was what showed him, which he didn't know before.
When was that?
That was
2015, it's at page
2015.
664. 664.
64?
664.
Well, is it part of his claim that the money, the account was not carried out in accordance with the settlement agreement? that would be a totally different allegation.
No.
I mean, all that happened, as far as we can see, is that the security was enforced and the property was sold, and he got what was left over after the debt, as recorded in the consent judgment, had been paid.
And then he had to consider and be advised as to whether that was honestly done. And our submission is that none of this, very little of this was honestly done. There are about 4 headings of fraud, some of which my learned friend is going to present to you. But
nothing that happened after the judgment can show that the judgment can make the judgment obtained by fraud. I mean, nothing that they did afterwards can be relied on to say that they obtained the judgment by fraud. And it's only if new information comes available of things that were known to them before the judgment was obtained. And you haven't identified any.
That would be a relevant consideration if the old principles prevailed and it was a manifested due diligence case. But Mr. Finzi was in the position of being sued and hassled for the money, in danger of losing his house. He was being exploited. His assets soon dissolved, as it were, into Jareth's hands. Now, maybe if he analysed the facts a bit sooner, he could have brought the claim a bit sooner. But what he did was to agree to a decision, to agree to a settlement agreement, which was predicated on the basis that everything had been done honestly. He doesn't even, the word fraud doesn't emerge from any of the conversations until 2017 when it's put into the claim. And that's...
They only sold the Avalon property because he had not paid the amount that he'd promised to pay under the settlement agreement.
It's true.
Which was about a third of the judgment debt, I think.
Yes, but why did he not pay the amount under the settlement agreement, and then they wouldn't have had to pay the Avalon? They wouldn't have had to sell the Avalon property.
Because it was too much for his finances.
Yeah. So it might be said against you that what changed was that he had entered into the settlement agreement knowing that really they would not be able to enforce it against him because he didn't have the money. And what changed was that they actually exercised their security over the property and did get their money back from the sale of the property. And that was something that he had not expected would happen.
But it is money to which they're not entitled in our submission.
Well, they are entitled unless you can show that the agreement was procured by fraud, and there was no basis for that at the time the agreement was made, so why is there now?
They're not entitled because, unbeknown to Mr. Finzi before 2011, the list of assets in what was called Appendix A, the list of the assets which were assigned to them, of which they were given the rights to enforce, did not include Avalon. And that is something that he only knew in August 2011. But can you say, and is it right to say, purely looking at that, is it fraud? The answer is it may be. And what he then went on to do was to look at the settlements, look at the amounts of interest that JRF were charging. The whole argument which we will be advancing, that the amounts of interest were grossly overcalculated, and he began to see the whole picture as being one which was rotten. But purely to act on that information about Appellant would have been premature. What he did finally, and the pleading sets it out in great detail, is to rely on a whole set of circumstances, not just Appellant, which show that JRF were.
So, am I right in understanding, Lord Gifford, that there was no specific material which caused the change of mind? It was a change of subjective appreciation as to the significance of the material that he already had.
Well, clearly, the mind that was brought to bear, I'm sure, was the attorney, because, but I'm not relying entirely on that. When he found that, when he was served with that list of properties, he needed to know more.
Well, what more did he discover later that
He discovered how the Avalon sales proceeds was distributed. He discovered how the Jamaica Beach. He discovered a lot about the courses of dealing of the company, which allowed him to put forward a case, a serious case, not just a speculative case, but a serious case that the company had been acting in a highly irregular and, we would say, on the surface, dishonest way. Can I ask you to do yours in mind? I had a feeling that we were not going to spend long about the nature of the law which the court applied and the Court of Appeal applied, because clearly they were wrong. And from your Lordship's questions, it is apparent that the real question is whether any evidence of fraud is there over and above the fact that Avalon is not on the list. I wonder if I may be permitted to ask my learned friend to intervene at this moment, because she has been studying the way in which JRF operated.
Yes, of course. I'm sure you and your learned junior will be mindful of the fact that there is a time limit.
Yes.
And we're going to have to stick to that strictly, I'm afraid.
Well, you've already helped me to cut it down because you came straight to the point.
Thank you.
Can you? If I could get them back.
You said it.
It's told you need election.
If it pleases your lordships, are you hearing me clearly?
Yes?
Yes. Indeed. If I could so follow on from my learned senior. Your lordships and your ladyship have quite correctly inquired about what has transpired since the documentation was received under the Access to Information Act by the appellant. And quite rightly, my senior has taken you through the process of the fact that the fraud was, as is pleaded, is one that is complex, one that is large, one that involves significant sums of money and certainly significant luxurious properties that would have fetched a very large price. And in fact, that they so did. But what we would like to urge upon the Honourable Board is that, separate and apart from the genesis, the basis upon which the appellant made the access to information request, which we have placed before the board, was not one that he had suspected fraud at the time that he made the request. When he made the request, and the court can see from the documentation in all the claims, he had been asking for an accounting. May I have an accounting of the interest? May I have an accounting of the debt? May I see the ledgers? May I see the loan documents? May I see what supports this? Now, of course, we know that there were numerous resistance, certainly resistance on all ends, which were sanctioned by the court. On one end, there was an application under the Money Lending Act, and the court did so find that he was not entitled to the accounting under the Money Lending Act because the JRF was exempt. And so there were these accounting issues, and that was the basis upon which the access to information request was made. It was through a process.
These requests for an accounting were before the information request to Finzi.
It was before. And in fact, if I should point the court to it, they're actually in almost every part of the pleadings.
Well, we don't need to go to them. I just wanted to get the timeline straight.
Very well. And so it was at the time when the access to information request, Your Lordships, there was no suspicion of fraud. What it was a fact-finding examination. When he received said documentation on August 9, 2011, that would have told us that there were certain debts that were transferred to FinSAC, for which they were then acquired by JRF. Now, from a bare examination of it, one could see that in the Avalon claim, the 30 million Jamaican dollars upon which their case was hinged as being the proof that they had acquired the Avalon debt, we could have seen that from the list. So that took us no higher, and this is an example, Your Lordship and Ladyship.
So you're saying it was on the list? That
the Avalon, the basis upon which they applied to the court in the Avalon debt was a $30 million, which I will explain to Your Lordship and Ladyship later on, that they knew at all material times that that could never have supported the Avalon debt, because it in fact was not the Avalon debt. So when they acted to enforce the debt, they knew from the beginning, and that is already pleaded in the pleadings, which I will lead Your Lordship to, the relevant paragraphs.
Well, if you can show a scintilla of evidence to support that on the documents, it would be very helpful.
Certainly. Certainly. I take Your Lordship to the fixed date claim form, which is at page 257. Your Lordship will note that the respondent claimed the principal and interest of 1.147,136 million.
This is the action in which summary judgment was given against Mr. Finzi, is it?
This is the one where there's a judgment emanating from Justice Cole, and that can be found at...
This is the 2004 action.
This is the 2004
Yeah.
case.
Yes.
Justice McIntosh, thank you.
Yes.
Yes.
And
so here...
Your point is that there was a claim for how much?
It was a claim for 1.147 million US. It was arising from a loan which they asserted of $464,472 US dollars.
Yeah.
Yes? And this was a loan that was issued to the appellant by Mutual Security Merchant Bank and Trust Company Limited. And it was used to complete the purchase. It is undisputed that it was used to complete the purchase of the Avalon property. This is why, hereinafter, Your Lordship, if I could refer to it as the Avalon loan and the Avalon suit.
Yes.
Now, JR asserted...
so the £1 million was that principal plus interest?
It indeed was. It indeed was. The principal would have been the 464,000 US dollars, and the additional sum was the claimed interest, which they had claimed from the date that the loan agreement was made in 1995. Now, JRF asserted at page 267, and that is at paragraph 18. that the defend. Yes,
257 at paragraph 8?
it's 267.
267.
267, indeed, Your Lordship.
Thank you.
It indicated there, and I will not take you through all of it in the interest of time. However, the material section is at the third sentence. It says, however, the list which is part of the assignment of the defendant's debt to the claimant and which is contained in the bundle at page 81 is a copy of the complete page of the list on which the defendant's debt, which is a particular debt that they were claiming at the time, inclusive of interest to that date, is identified in United States dollars.
Now, this document is what?
This document that it was the affidavit that they used to support the claim. So the claim originated by a fixed date claim form. And in the affidavit that they used to support the claim, this was a section that they detailed how they came by the debt, how they came by the acquisition and assignment of the debt. And so they refer to, at that time, to a page 81, which for the purposes of the bundle is at page 354. It's slightly difficult to read, Your Lordship. The reflection of time, I think the copies are weathered. But what that document shows at 354 is a classified loans sold to Recon Trust by NCB, and this was a document exhibited to the master agreement for sale and purchase of credit receivables. Now, what this was, it was the exhibit to the master agreement. So when the bank was selling to the subsidiary of FinSAC, they're selling particular loans. This loan of 30 million Jamaican was sold to FinSAC, was acquired by FinSAC, and you will see at page 365, which is the Exhibit A to the deed of assignment to JRF, you will see a singular account, XA account number 1021928.
Sorry, 355?
It is 365. 365.
And the $30 million, that's Jamaican dollars.
That is Jamaican dollars.
And what is that equivalent to of the figures that we've been looking at so far?
So the $30 million at the time, when it was converted,
Yes.
you will see on page 277.
Well, just tell me which.
It was 15 million.
50 million.
Jamaican dollars. So the
Yeah,
loan.
but we were looking at a loan of US dollars 464,000 plus interest was $1 million.
Yes.
US dollars. Now this $30 million is Jamaican dollars.
That's
is
the
that
problem.
a completely different figure or is that a similar?
That's the figure that they asserted to the court was 464. And that is a problem why we say that this particular loan was never acquired by JRF. And this
They were saying the 30 million Jamaican dollars was the principal value of this loan of 464 US dollars.
what they were saying in this affidavit was that that was a principal, that was a debt inclusive of the interest to that date. So when they refer to 30 million, based on the affidavit, they said that that was the defendant's debt inclusive of interest to that date. But we say that they could have never assumed that, and that is further supported by the fact that the loan documents spoke to the 464,000 US dollars. The documentation themselves mandated that the appellant pay back in United States dollars. That can be found at 280.
But the figures that we have at 365, are those Jamaican currency or US dollars?
365 is the $30 million, which is Jamaican currency.
Jamaican currency.
Indeed.
And the figures that we have in the pleaded claim
Are US.
257 are US.
Yes.
And are they the equivalent amount?
There's no correlation between the two. There was at no point in time in any of the documentation before the court or in documentation before your lordship, which were in support of the pleadings, was there an explanation as to how 30 million was 464. How there was
If it's interest, then it's not the 464, it's the million, isn't it?
well, perhaps your ladyship could allow me to look at page.
Before you would go there, can I just ask, 365 is a document which came into Mr. Finzi's possession at what stage?
I crave your lordship. 365. .365 was a document that was exhibited as a said affidavit at the time when the claim was filed. So this is a
2004 claim. Yes.
This is a 2004 claim. So the documentation at page 365 was exhibited to the affidavit
And this
in
treats
support.
30 million Jamaican dollars as being 653,000 US dollars, is that right?
What they did at the time when they acquired the debt, when GRF acquired the debt, they did a conversion of US 1 to 4740. Now, that's simply a conversion. That's neither, we neither know whether that is, that for all intents and purposes is just a conversion. And the conversion could be a conversion as at the time, a different rate as it would be at the time when GRF acquired it. But what is even more interesting, Your Lordship, is that at page 663, Your Lordship, if you could turn with me, 663. This was what Mr. Finzi had received under the Access to Information Act, which Mr. Errol Campbell.
I'm sorry, this is?
This is what the appellant had received under the Access to Information request.
Right. This is the August 2011.
Yes. And so you will see that the $30 million, which is number one, the $30 million, and if I could preface this by saying, there are two tables. The top table shows the debts acquired from the bank. So this was what FinSAC had acquired from the bank. So what FinSAC acquired from the bank was this $30 million, and to that, there would be interest on it. So that was the principal amount. There was clearly here no correlation between a principal sum of 464 and a principal sum of $30 million. In fact, when they went to court, and that is the respondent, there was no explanation as to how these two figures matched up in any way. In fact, what was served on the appellant, if I could, Your Lordship and Ladyship, what was served on the appellant is a notice requiring him to pay back on a 464,000 US debt. And I will ask Your Lordship if you could, there's a notice of assignment of debt on page 371. On 371, GRF informed Mr. Finzi, that is the appellant, that there was a deed of assignment dated the 30th of January 2002, and that they had acquired the particular debt or loan account of 464,472, which was given to him by Mutual Security Merchant Bank Trust Limited. At the time when they wrote to Mr. Finzi, they would have known that they did not acquire it. And in fact, this is bolstered by what Mr. Campbell, by way of the information that we have received, that FinSAC neither acquired it, nor could it have been sold to GRF. In that regard, we assert, Your Lordship, that...
Well, why do you say that the two aren't the same?
Well, certainly, there are principal sums that were sold. The principal sum which you see FinSAC has identified. FinSAC identified principal sum. What was sold was credit receivables. So they identified principal loan sums, and then they applied interest. The credit receivable would then be the principal plus the interest. And that is what was acquired. Now, there was no loan. The loans remained in the currency for which they were taken. There was no loan for 464. And in fact, in the particulars of claim of Mr. Finzi, the appellant, in these proceedings.
There was never a loan of 400. How can you say that there was never a loan of 400?
Because we assert that that loan had been repaid. And if it were in
When
fact,
had it been repaid?
It had been repaid before the bank had collapsed. And for such a loan of such magnitude, which tied with it such a lucrative piece of property by way of a security, if it in fact were a loan that was still on the books of the bank, it would have been one that was transferred. But the plain fact, Your Lordship, which I would ask you to consider, is that the loan was never transferred to FinSAC, therefore it could never have been acquired by the respondent. So when the respondent initiated proceedings, served a notice that he was assigned a particular debt, demanded of him to pay, go to court, and rely on the 30 million Jamaican dollars without more.
So when do you say it was repaid?
It was repaid prior to the bank collapsing, and that
You said that.
But that was asserted in the 2004 proceedings, and the judge said there was no evidence of that. I mean, all this material was before the judge in the 2004 proceedings granting summary judgment. The 30,000 attached to the assignment was there, wasn't it?
in fact,
And the point was there to be made, no doubt it was made on behalf of Mr. Finzi, that on the face of it, the 30 million doesn't correlate with the $654,000 or whatever.
that point was not made.
But
Well, it was there to be made.
So the point of whether the two figures correlated with each other
Yeah.
was not made.
All right, but
What was made was that we, if I could, I apologize for
No, but it was there on the face of the documents to be made.
Certainly, perhaps, one would say that it could be made, but at every juncture, and I would ask Your Lordship to consider, at every juncture when the appellant attempted to make applications to either stay, further and better particulars to support the loan, what he was told, and remember, Your Lordship, if I could urge upon the court, as was stated in Takar, you do not have these transactions from a place of thinking that there is an automatic fraud.
But isn't the simplest thing then to produce the documents to show that he repaid the loan?
At the time, in fact, that would have been so, but at the time he did not have it.
But
He's never produced any documents to show he repaid the loan.
But what is important, Your Lordship, is that they have never produced any document to show that they have actually acquired that loan.
Well,
and that is
but I don't understand now what your case is. Is your case that there was a loan, it was repaid before FinSAC came on the scene, and therefore FinSAC was wrong to purport to assign it to JRF? Or are you saying that the loan which was assigned to JRF by FinSAC for the 30 million Jamaican dollars is some completely different loan from the 464,000 US dollars? What is it that you say is there on the list of assigned debts?
What we say is that when JRF enforced the 464,000 US dollar loan, they had not acquired it. And
why do you say, are you saying that they hadn't acquired it? Why? Because it wasn't sold to them? Because it was sold to them, but in fact it didn't exist? Or
it was not sold to them.
It was sold to somebody else?
No, we say it was not sold because it was not a loan that was current at the time. There was nothing to sell.
Because you say it was repaid?
We
Say-
assert that
There's
it
no
was
evidence of
repaid.
repayment.
No evidence of repayment, but what I will ask the court is consider the status of GRF. GRF is a debt collector. They can only collect on debts that they have acquired.
But they paid, presumably, they paid FinSac or whoever for this debt, maybe a percentage of it, but they didn't acquire this for free.
No,
So
What is your explanation? What do you say the 30 million Jamaican dollars represents?
yes, we say so in our particulars of claim that the $30 million actually represented an overdraft account, a personal overdraft account, and that is why it's in the name of Winston Finzi. That personal overdraft account was being repaid. And
Was being what?
was being repaid. In fact, it was repaid before the bank was collapsed. And so that is why it would not form
Oh, so that,
part of.
well, does that mean it is the same loan but was repaid, you claim, before the bank collapsed? Or it's a different loan?
No, so the $30 million was an overdraft account. It is not in any way connected to the loan that was the loan for Appellant. So this 464 that they went to court and enforced and indeed enforced and got an equitable mortgage over the Appellant property was not connected to the $30 million loan, and it could not have been a part of the FinSac acquisition and further assignment by GRF because it was not a loan at the time.
Okay, well, do you have documents to demonstrate what it was? If you say it wasn't this Avalon loan, but something else, the overdraft, is that, are there some documents that show that this 30 million was a separate overdraft loan to Mr. Finzi?
We do not have any documentation to support that, but what we do have is what was filed. The burden of proof rests with the party who brings the claim. And the party...
Well, no, you've got to do better than that. If you're saying that this doesn't correspond, but it's an overdraft, you're making that assertion.
And we have made that assertion.
So far, all you're saying is you assert it was an overdraft, there's no document to support that, and you assert that the other loan was repaid, and there's no document to support that.
Indeed, the court, there is no documentation to support that. And I will be frank with the court. But what I will urge upon the court is not to view it from the stance that it is the appellant who must bring this documentation to the
You're
court.
the one who's alleging fraud, and it seems to me at the moment that there's not any basis at all for alleging fraud, let alone even for saying that the two were different loans.
But there was, but your lordships, if I may, and I have to move on from the point because there are other instances of fraud.
Well, before you move on,
Yes.
are you saying that the 30 million personal overdraft account was repaid?
We are saying that
That was
not
repaid before the
repaid.
proceedings were brought.
That overdraft account was not repaid. What we say was repaid was the 464,000, and that is why it did not form part of the.
Right.
Yes, that is what we say.
But you say that the $30 million Jamaican dollar overdraft was not secured on the Avalon property.
It was not.
Right. But even if it wasn't secured on the Avalon property, if they are entitled to judgment on that overdraft, then couldn't they get the Avalon property sold to pay the judgment debt, whether or not the initial debt had been secured on that, because they're entitled to that money?
They would not have been. The Avalon property was being acquired by a company, an entity, Avalon Investments Company Limited. They would have had no access at all to the Avalon property. The Avalon property was separate and distinct. The only reason why the Avalon property is being placed into the mix as a property which they could levy on was the fact that they had used this $30 million and attached it to Avalon, when in fact that cannot be so. So if they did not acquire the loan of 464, they could have not been able to acquire an equitable mortgage over Avalon property, because Avalon was being purchased by a company.
Right, just going back to page 365.
Indeed.
There we've got, as you said, 10201928 Finzi Winston.
Indeed.
Gives the US dollar, it gives the Jamaican dollar figure of 30,980,631, and that has been converted at a rate of of 47.4 Jamaican dollars to $1 US, and that gets you to the 653,599 figure.
Yes.
There.
Yes.
So that 39,80631 is the Jamaican dollar equivalent of the 653,599. Now, what is that 653,599 figure then?
It is simply the conversion of the $30 million.
Yes, but what loan is it?
No, it's a conversion of the $30 million, which we assert is the overdraft.
They're saying that this is an assignment of a debt of 653,599, which converted makes the 30 million figure. But that debt of 653,599, which is what is said to have been assigned to JRF by FinSac, by this Exhibit A to the deed of assignment, which of the loans we've been discussing is that figure of 653,599 American dollars?
That figure is the individual account of Winston Finzi. That figure is what they had used to support the Avalon debt. And
yes.
so
I'm just asking you what you say it is.
Yes, we say that that is the individual personal overdraft account of Winston Finzi, which is not connected to in any way Avalon, and which we intend to show in short order that they had actually recovered those monies twice. If I could turn to the second one, which I think may be a little...
Ms. Tellen, all of this was apparent in 2005 or 2004 when the action was brought.
I think what was not apparent at the time was we would not have known at that time whether the 454 was sold to, was acquired by FinSac and sold to JRF. That we would have learned in 2011. And throughout the course of 2011 onwards to the time when we made our claim in the courts, Your Lordship, it was the fact of the fraud had not unraveled itself until there was a comprehensive examination of all of the cases. And on an examination of all of the cases, we realized that there were overlap in the claims.
So what was it that you learned in 2011 that was significant?
What we had learned under the access to information request. So what we had learned in relation to the Avalon debt was that they had in fact not acquired a 464,000 debt.
Well, what you learned was that they had acquired exactly what they had assigned in 2002, and so it just supported this table which you already had.
Right. So that is exactly why, Your Lordship, we say that we did not, on looking at this, we would not have readily thought fraud. But when we go back and examine all of the cases collectively, we realize that the $464,000 and all of the loan documentation and everything which supports it, the requirements thereof, could never have been the $30 million. And that we could have only unearthed after comprehensive examination of all of the cases.
He presumably knew that he'd paid off the loan. He presumably knew he had an overdraft of nearly 31 million Jamaican dollars. I mean, these are not facts unknown to him. These are debts that he owed. So what is it that he found out?
There is if I could ask your Lordship, there is a letter that came to counsel who was examining the fraud, and that can be found at page, I'm sorry, if I could, page 664. That letter was served, it's dated April 30, 2015. In that letter, there was a detailed accounting of all of the loans, and your lordship will note at that time that what was indicated to us was that there were, in fact, 14 accounts that were acquired by JRF, which they asserted.
So where are you, sorry?
I am at 664, my lady. 664 is a letter from the attorney at law for JRF, addressed to the attorney for Mr. Finzi at the time, and it rehearsed, of course, that there was the long line of attorneys, approximately 10, your lordship, that had been a part of these proceedings representing Mr. Finzi. But interestingly, what it provides is a statement of account of all of the sales of properties, how they were applied, including the last property which was sold, and that is the Jamaica, and that is the Appellant property. Now, it is that document, if I should be so candid with the court, it is this document, amongst the other suspicions that Mr. Finzi had.
Well, can you show us what the relevant bit of this document?
Certainly. The court will note that on page 668, and there was the sale of Jamaica Beach Park. The Jamaica Beach Park, if I could segue into that, and we don't take issue with the sale of that, if I could say so openly to the court. The Jamaica Beach Park property was known as Maho Bay land. They had sold to a hotel chain for $6 million US. Now you will see in the second series of tables, the one that says balances as of the 16th of the 9th, 2005, that before they applied the proceeds of the sale of $6 million US, these were the outstanding balances for Jamaica Beach Park. The US Jamaica Beach Park loans were $3.6 million, and the Jamaica Beach Park Jamaican dollar loans were $223,377 and $223 million, if I could. After they applied the payment, it is clear that there was no longer any debt outstanding for Jamaica Beach Park Jamaican dollar accounts. If I could go back just shortly, if I may, and I don't want to take you too far, Your Lordship, if you could look back at the letter from FinSAC.
I'm sorry, I'm not following this.
Is Avalon feature in this at all?
Avalon is only featured insofar as there.
So far, you're not saying there's anything wrong with this.
There is a statement of account that is provided at 666.
Yeah.
And that statement of account would have detailed to us all of the expenses and I would say net costs associated, net proceeds of sale after JRF had satisfied all that they claim was due to them.
But this was the net proceeds of sale. Which property is that of? Of both, which property is that the net proceeds of sale?
For the one at 666 million?
Yes.
Yes, that is for the Avalon.
But why is all the rest of it to do with Jamaica Park?
Right, so the Jamaica Beach Park is concerning a different property that they had exercised powers of sale.
Yes, but what is it on page 666 that
What?
tells us that this net proceeds of sale relates to the Avalon property?
No, it does not relate to the Avalon. I've moved on from that point, milady, if I could, in the interest of time.
Oh, we're not dealing with Avalon anymore.
Oh, we're not dealing with, I will round back up to Avalon after I've dealt with the other aspects of it, if I may, Your Lordship.
Right, so this at 666 says there was all this debt for Jamaica Beach Park, whatever it's called, Beach Park, and that's all been paid off by the sale of Jamaica Beach Park, and you don't take no issue with that?
Well, we don't take issue with the sale of it. What we take issue with is the application of the proceeds of the sale. So what this shows to us, milady, and I will ask the court to accept as it is stated there pellucidly, is that the Jamaican Jamaica Beach Park debts were paid off, so to speak. But if you look back at the information that came from FinSAC, the information that came from FinSAC did not show any Jamaican Jamaica Beach Park loans. So there were no Jamaican Jamaica Beach Park loans that were acquired by FinSAC and sold to JRF.
Did they show Jamaica Beach Park loans in US dollars?
They did in fact show Jamaica Beach Park loan in US dollars, and if they had applied it, and at the Jamaica Beach Park, if you will look at me, the actual, if you will come along this journey with me, Your Lordship, is the title for Jamaica Beach Park is on.
I'm simply not following what you're saying. I understood that as a result of the default of Mr. Finzi to perform his part of the settlement agreement, that property was sold and that there was an excess as a result of that which was paid to him.
No. So the Jamaica Beach Park, the Jamaica Beach Park property, the sale of it happened well before the settlement agreement. So this is another element of the fraud which we have pleaded. The Jamaica Beach Park property, the title, it was actually sold on, it was sold in June 30, 2005. So before there were any proceedings concerning Jamaica Beach Park, that is, can be found at 650, page 650. Uh, 650. The title is actually on 642. I apologize. That was 642. That's the title. You will see at page 643 that there were two mortgages endorsed on the left-hand side of the page. One mortgage for $2 million and another right below it for $258,400 United States currency. You will see here that there was the transfers, the relevant transfers. Transfer to NCB, further transfer to JRF, refin, then a transfer to JRF, for which there was the ultimate transfer to Jamacotel Limited. So when they exercised these powers of sale, it was not through the intervention of the court. It was through their exercise of powers of sale as a mortgagee. Now, if I should go back to hold the application of the proceeds of sale, Your Lordship.
Application of the proceeds of sale of what?
Of these sums that they recovered. So they sold the property for
the sale
Jamaica
of
Beach.
what?
of Jamaica Beach Park
In 2002?
2005.
2000.
Now, which page do you want us to go to?
Yes, Your Lordship.
Which page? Yeah, sorry.
It is
I mean, you showed us a letter.
it was 666.
Which one? Sorry.
666.
650.
666.
Okay,
668. I apologize.
668.
So it says here that Jamaica Beach Park accounts after the 2005 sale, after payment, it had been reduced from, the US dollar was reduced from 3.6 million to now 2.25 million.
Sorry, where do we see that?
And I start first at the balances, which is the second set of tables. The balance as of 16th of the 9th, 2005, before payment. And payment is referred to as a payment of the proceeds of sale arising from the sale of Jamaica Beach Park. You will see where the two tables are segregated into US and Jamaican dollar debts.
Mm-hmm.
The US dollar debts, the total, which is at the right bottom column, they asserted was 3.6 million.
Yes.
The total for the Jamaican debt was 223 million. When they applied the proceeds after payment, which you can see in the other two sets of tables, they extinguished all of the Jamaican dollar debts, and they reduced the US dollar debt to 2.25 million. If you should go back, Your Lordship, or if I could take it there simply, the Jamaican dollar, the disclosure from FinSAC did not indicate any Jamaican dollar Jamaica Beach Park loans.
Well, that was right, because they'd all been paid off in 2005.
No, it would not have been. At the time when it was acquired, by FinSAC, FinSAC did not acquire any Jamaican dollar Jamaica Beach Park loans. The actual sale happened in 2005. FinSAC acquired in 1998.
Mm-hmm. So what loans did they acquire?
They acquired all of the US dollar loans.
2 US dollar loans?
No, they acquired all of the US dollar loans, Jamaica Beach Park loans, which are listed at 1, 2, 3, 4, 5 loans.
So which page?
663.
663.
663.
Yeah.
You will see numbers listed 2, 3, 4, 5, and 6 are US dollar Jamaica Beach Park loans.
Right.
You will also note that number 2 has a principal sum of $258,400, which is which was one of the mortgages endorsed on the Jamaica Beach Park title. Mm-hmm. There are no Jamaican dollar loans that were acquired from NCB in 1998 and further sold to JRF as at January 30, 2002. And you can also confirm this by the second half of the table, which shows the debt sold to JRF as at November 1, 2001, and transferred to JRF as at January 30, 2002. So when they exercised powers of sale, they were correct in the sense that there is in fact a valid and legal mortgage.
And who exercised?
That is the respondent in the proceedings, JRF. So we take no issue with the actual exercise of the powers of sale as mortgagee.
But I thought you just said that they didn't acquire any of these
what we take
Jamaica dollar loans.
Yes, so they were correct to exercise powers of sale because they did have the US dollar loans. What they were incorrect is to apply $223 million to Jamaican debts which they did not have.
So the $223 million Jamaican was wrongly applied?
Was wrongly applied because they did not acquire those debts.
But wasn't it applied to pay off the debts that were still owned then by the bank?
Well, the bank...
To whom were the Jamaican dollar debts then owed at the time the property was sold?
In the proceedings, there was a defense and counterclaim which was filed where Mr. Finzi itemized all the payments that he had been making.
Yeah, but the fact that the debts weren't assigned to FinSac or JRF, so they must have remained with the bank then.
No, unless there were no debts, milady, which I would ask the court. This is a debt collector. This is an overseas company, milady.
Yes, but it seems that the sale of the Jamaica Beach Park property were used to pay off Jamaica dollar debts. Right.
Indeed.
Yeah, but if those debts were secured on that property, then what's wrong with that having happened?
Those debts were not secured on the property, milady.
Well, all right, whether or not they were secured, those debts were owed to somebody, and now they're not owed because the property has been sold.
Well, milady, there were no loan documents that were shown for these debts. All that was shown to the court was the fact that they claimed that they have these debts. They did not show loan documentation that showed that the appellant had even the existence of these Jamaican dollar debts.
Well, has he shown that has he said anywhere that he never owed them?
What he
These
did,
are debts that he is alleged to have owed, which he should know about.
what he did say was that he was making all the payments on the Jamaican dollar debts, and he itemized in his defense and counterclaim the payments that he made.
But those debts have now been paid off with the proceeds of sale of Jamaica Beach Park.
Those debts are paid, those alleged debts are paid off on loans that were not acquired by the debt collector.
Which proceedings was that dispute in? The one that ended in the settlement agreement, or a different one?
The proceedings were 2005 HCV 05397. That can be found at page 446 is where you can find the claim form. 446.
446, and this is the 2005.
This is a 2005. So what happened in the 2005 claim is that after the payment was applied, you will see here from their own accounting that they said that the Jamaican dollar debts had been, Jamaica Beach Park debts had been extinguished. But if you could turn with me to the 446, you will see that only 2 months after, that's December 2, 2005, after they applied the proceeds, only 2 months after they filed in court a claim for Jamaican $64 million and $6 million US. Which they assert were the residual balance on the Jamaica Beach Park accounts.
That must have been on the US dollar accounts then.
No, milady, because what they indicated was that the $4 million, prior to the proceeds of sale, what they had was $4 million that was outstanding for the US. And they had $233 million in Jamaican debts, Jamaica Beach Park debts. In September 16, 2005, when they applied the proceeds of sale, they now had brought the the US dollar loan down to
2.254, I think it was.
2.254, and the Jamaican dollars were extinguished.
Yeah.
2 months after, 2+ months after, not yet 3 months, they filed these proceedings in court, which state that they were now claiming 64 million Jamaican and $6 million US dollars, which you can see from the particulars of claim. The particulars of claim at page 449. They assert that Jamaica Beach Park defaulted in its loan obligations, and as such, this was a residual amount. The court would note that the particulars of claim attaches no documents. No documents are either referred to in the particulars as being annexed. And at no point in time has the court seen loan documentation to support any of these loans. In fact, if indeed, as the board finds that there were no Jamaica Beach Park Jamaican dollar debts that were sold to JRF, giving them the legal status as being able to enforce sale, then all of the US dollar debts would have been extinguished.
That's exactly what he said in his defence at 452, that there is no debt, put to strict proof of all the matters. They've exercised their power of sale, they got $6 million, and they paid off the debts, and therefore believes this demand to be unlawful and baseless, is what it says in 453.
Yes.
And that was dated the 13th of February 2006. So that defence was put forward.
In fact, that is so.
And what ultimately happened in those proceedings?
In those proceedings, they obtained a freezing order on May 2, 2006.
That's 2005 5397 proceedings, but isn't that the one that was ultimately settled by the settlement agreement in 2012?
Indeed, there was a settlement agreement, and if in fact the court has to look at the matter from the context of if he had extinguished the US dollar loans by virtue of the sale, the legal sale of this Jamaica Beach Park property, there would have been no claim in the courts. There could not have been. But instead, they applied it to Jamaican dollar debts first, not the actual mortgage which they intended to secure. So they didn't apply it to the US dollars that were evidenced on the face of the title. What they applied it towards Jamaican dollar debts.
These were all matters which were apparent in 2006.
There were apparent insofar as, Your Lordship, they were apparent insofar as we could see that there were problems.
But you're saying it wasn't until 2015, are you, that you got sent the statement of account which disclosed the fact that the money had been used on the Jamaica loans? Is that the case?
It is a case that the letter which we received in 2015 placed squarely all of the debts and their accounting and the proceeds of the sale and other costs and fees in a comprehensive document, which allowed the appellant to then use same in conjunction with the 2011 disclosure from FinSAC to further his investigation.
So you're saying that what happened at this time was that the sums were applied to the wrong account?
Sums were applied to accounts that were not purchased.
And you said that didn't become apparent until the 2015 letter. Is that right?
I say that it would not have become patently apparent because there is another letter which was sent, and the other letter, it can be found at 649.
Let me just look for a moment at 452 and my lady's point.
452.
That essentially this was the defence which was pleaded. This is paragraph 3 of the defence.
So, what the defense essentially placed squarely the fact that they had, arising from the sale, received enough monies to extinguish the loan.
6 million.
The
But
6
what
million,
you're saying it doesn't show in the defence because he didn't know was that money had actually been used to pay off other loans which weren't part of the assigned loans.
yes, so he would not have known at the time that there were in fact no Jamaica Beach Park, Jamaican dollar
Maybe
loans.
those other loans had a prior charge on the property, in which case they would have had to pay off those loans before they paid off their own loans, wouldn't they?
Well, I don't know if that assumption can be made readily in the absence of documentation to support that.
It's also your case is that the $6 million can be shown not to have been owed by the statement in 2015.
It is our case that they would not have had a claim for the $6 million because
It's
the $6
inconsistent
million
with the
would have
account
been
that was
applied.
sent in 2015.
Indeed, indeed.
But you were going to show us another document that
Indeed,
you had
indeed.
got.
Yes, Your Lordship. I'm getting there. I asked the court to turn to the judgment of Leng at page 173, and this is a 1 minute explanation.
Sorry, page?
173, Your Lordship. At paragraph 89 to 90 of the judgment, the court, Justice Leng, found that, and I will go to 90, but 89 gives you a context of why he said what he had said. He said that Mr. Beswick appears to be correct in his submission as to the method employed in calculating this figure, and it was how in fact how the 30 million.
We're now back to Avalon.
We are actually not back to Appellant.
Oh, okay.
We're in some way.
I'm sorry.
But that was not that 39,80631. I thought that was a Jamaican dollar figure.
Yes, this is an error in the judgment.
Yes.
It's an error in the judgment, lady.
Okay. Right.
It should really be Jamaican dollar. What he found is that upon an assessment, he agreed with counsel for the appellant that the method employed in calculating this figure was through a process of compound interest and ascribing simply interest at 30%, 45%, and just at will, any percentage that they so chose, which made the figures balloon from $30 million to $358 million. What he found, interestingly, at paragraph 90, which I'm not asking the court to make a finding on, Your Lordship, is at this stage, is simply that the court identified that it appeared that the $30 million exhibited to the assignment appears to be the same facility as the Jamaica Beach Park overdraft account. Now, you will note, and Your Lordship so rightly stated, that this $30 million was what was used for Avalon. The court here formed the view that the $30 million appeared to have been the same facility that was used in the Jamaica Beach Park overdraft facility, for which they had then used it again, according to what the Lordship found. Used it again, applied the various compound interest and interest rates at will, and it ballooned to $358 million, from which they applied the $200-odd million from the proceeds of the sale.
Do you have a reference to the statement of account that says here does refer to the overdraft account?
It is at page 630. 630, I apologize, is where the letter is, but the actual account can be found at page 635. This was a submission made by previous counsel for Mr. Finzi that the lack of documentation in support of specific loans, save and except for Appellant loan, which we know we actually saw loan agreements for. What had been provided were just these accounting, just sheer accounting. And if the court even examines it, you will
is this at 635, is this Jamaican or US dollars?
This is Jamaican.
But where's it starts off with a $27 million figure.
Yes, it starts off with a $27 million and it somehow reaches down to 30,685,645.50, which is the third line down.
Okay.
And I really, Your Lordships, don't want to belabor this point of the finding of Justice Lang, only to say that this overdraft facility of 27 million became 358 million. Your Lordship will note even then that if you even take a date on the left-hand side, you will see we're on numerous dates, the same date. You will find that they applied interest 3 times, sometimes 4 times, and they applied it at 30%, 45% from the date at which they purport, because there's no evidence. There's no evidence.
That 45% is an annual interest figure, and it's seems to be being applied monthly in a compound way. Is that right?
I can't say whether it's an annual interest figure, because that figure changes. I can't say, but it says the number of days is 30.
Yes.
So they would apply 45%, compound it to the principal, and then they would then apply 45% on the principal again.
Yes.
And the basis for so doing, Justice Lang found that, well, that is a tribal issue. You know, if in fact the reasonable diligence condition does not apply, that clearly is an issue for trial.
It's not an issue of fraud, it's an issue as to what interest rate was agreed.
Well, in the absence of documentation, which they would have needed to supply to the court, and which we assert they will not find any documentation to support that.
Was this secured on the Jamaica Beach Park property, this overdraft?
No.
It wasn't?
It was not. In fact,
it says, well, why is it headed Statement of Account Jamaica Beach Park?
Because this was what the respondent asserted was a Jamaica Beach Park loan, Jamaican dollar loan. Now, the court will recall that there is no Jamaica Beach Park loan, Jamaican dollar loan that they had acquired. This accounting, without more, which this accounting can be derived, we don't know the genesis of the accounting.
Does it correlate with the other statement of account that you were showing us? So these monies, Jamaican dollar monies, were they paid off out of the sale of the
you will see at
Jamaica Beach Park property, so that when that Jamaica dollar account was cleared, it was this account that was being paid?
It was this account that was being paid, and you will see at page 636, which is the page below, they applied the sale. The text is very fuzzy, but they applied the sale in that block.
The blocked out, the
blocked
dark path.
That is when they applied the sale. So even though they wrote to the appellant and informed him that they had extinguished the account, they somehow was able to find, based on their own accounting, that 64 million was still due.
Ms. Turner, this statement of account is annexed to a letter dated the 18th of May 2006.
Yes.
Why weren't these matters of which you now complain apparent at the time?
I think at the time, my lord, we did not know whether a Jamaican dollar account was ever acquired by Jamaica, by JRF. We would not have known at the time. But we approached the matter on the basis that if you say we owe, please show us that we owe. And if we are locked out of the court in getting information as to whether we do in fact owe. There are freezing orders being made against us. There is, or house is being placed in public documents as being something that they can levy on in satisfaction of the debt. We, out of a sheer, I would say, frustration and fright, entered into agreements that would have negotiated what we could have paid back. So I think the roundup point, Your Lordship, if I could say, is that a settlement agreement and the judgment, which the respondents assert was by trial, but in fact paragraph 1 of the settlement endorsed on counsel's brief, in fact says that it was not by trial. And if I could just, I think it's an important point.
Well, before you go there, Ms. Tolan, you only have 5 minutes left.
Oh my.
And I don't know whether there are other parts of your submissions that you feel you need to develop.
I think I can do it within the 5 minutes. The 609, 609, Your Lordship. The settlement endorsed on counsel's brief at paragraph 1 says that the claimant and defendant agree that the court has applied sanction against the defendant, being Mr. Finzi, and they struck out his defense and entered judgment for the $3,761,908. And to put it in context, this is the 2005 claim that they had claimed for the $6 million US and the 64 million Jamaican.
So what was the sanction for that? What had he failed to do that led to the striking out of the defence?
Does it matter?
I have to confess, I am not sure. I'm not sure. And I do not see those documentation before the court in these proceedings. What I can say is that the court, the order of the court, which can be found at 607. 607? Not 607. It is in fact 605. I apologize. 605 indicated final judgment as the heading, and upon the matter coming on for trial, judgment is entered in a particular sum. But in fact, the settlement agreement and the particular sum was the said sum of 3.7 million US. In fact, the settlement agrees, all parties agree that it was in fact because the defense was struck out that judgment was entered. I say that to say that there was in fact no trial that had occurred. And so the settlement that the appellant had negotiated was hinged on trying to see whether he could negotiate a third of the judgment sum. He was trying at that time, Your Lordships, to see how he could stay the hand in some way or chart the process that they would apply against him by entering into a settlement. And that settlement would never have arisen if in fact the proceeds of the sale had been applied to the US dollar accounts which they in fact purchased. So if they had applied it to the US dollar loans, that would have extinguished the debt. There would have been no claim from which a judgment would then be entered, and then no settlement agreements. The fraud follows along, and I know Your Lordship and Ladyship has inquired. Is it fraud, or is it simply misrepresentation or mistake? But these were information that the debt collector who purchased certain debts, he did not purchase all debts, he purchased certain debts, and it is only those debts upon which he had the legal status to enforce. He would the JRF, the respondent in these proceedings, would have been aware. Mr. Finzi would not have. And so when they took the actions that they did, served notices to say, you owe this particular debt, went to court, obtained freezing orders, did not disclose true accounting as was being consistently requested. And further, when they went and they got judgment and sold these critical, lucrative pieces of property, Avalon was 9 acres of beachfront land. Jamaica Beach Park was 11 acres of beachfront land in the tourism hub of Jamaica, Montego Bay. We say that even if the court says, but Mr. Finzi owed debts, it is not for these respondents to enforce, because these respondents' sole purpose was to realize the debts which they purchased by enforcing assets which would then enrich themselves. And they have so enriched themselves to the tune of $4 million US in one instance from the Avalon sale, and other sums that the 1.7, which was a judgment, the 1.37, which was a judgment in Avalon, which Mr. Finzi paid. Now, in line with the case of Park, a person cannot take a deliberate decision not to rely on evidence of fraud unless he is not only aware of that evidence, but he knows he can rely on it in answer to the case brought by his opponent. At the time when the appellant received this information in 2011, the full state of affairs so as to allow him to comprehensively plead fraud in the manner in which he did was not unearthed at that time. And I ask that in the circumstances, there was no deliberate decision not to investigate the fraud. But rather a decision to comprehensively investigate so that they could meet the requirements of the court as it relates to fraud, to specifically plead. And that in and of itself would have taken significant time.
Well, thank you, Ms. Terran.
If it pleases you.
We're going to rise for a few moments to consider where we are and resume. Final phrase.
Where an action is alleged, where an action alleging fraud is being brought to set aside previous court actions and settlement agreements, the first question to be addressed is whether the new evidence shows a conscious and deliberate dishonesty, which is relevant to the various orders, judgments, and agreements now sought to be impugned. The respondents, of course, submit that the answer to that question is no, it does not. The second question is whether the new evidence is material, that is, showing that the fresh evidence would have entirely changed the way in which the first courts approached and came to their decision. Respondents submit. The answer to that is also no, it is not. The fresh evidence is neither fresh nor new. Sorry, not being heard? Am I not being heard?
Yes.
Fresh evidence, my lords, is neither fresh nor new, and the material contained in it was before the courts below. The third question is...
Sorry, could you... I wasn't able to hear the first question. So could you just repeat that?
First question, my lords, is whether the new evidence, that is the Finzi documents, shows a conscious and deliberate dishonesty which is relevant to the various orders, judgments, and agreements now sought to be impugned. That was the first question.
Thank you.
And the respondents submit the answer to this is no, it does not. The second question is whether the new evidence is material. That is, whether it is showing that the fresh evidence would have entirely changed the way in which the first courts approached and came to their decision. And we submit the answer to that is no, it is not. The evidence is neither fresh nor new, and the material was before the courts below in the various actions. The third question is, how does the new evidence impact on the evidence supporting the original decision? And we submit the answer to that is, it has no impact, precisely because its conduct, its content was part of the evidence before the court in the original decisions. When your lordships examine each of those issues in more detail, we hope you will see that there is no miscarriage of justice here. Just to be clear, the respondents accept the decision of the UK Supreme Court in Dakar, delivered after the Jamaican court decisions, as being highly persuasive in Jamaica, and have not come here to say that reasonable diligence in bringing forth the new materials is required. Rather, the respondent's case is that the material is not new, and its content was raised in issue between the parties in their original forays. The respondents submit, my lords, that nothing in the material from Finzi obtained by Mr. Finzi in 2011 proves the earlier outcomes were tainted by fraud. Accordingly, JRF has perpetrated no deception on its opponent, the court, or the rule of law. Those then, my lords, are the general principles.
And those principles you take from Lord Justice Aiken's judgment in the Royal Bank of Scotland, which was approved.
Yes, I do take those principles from that, Lord Aitken's principles. Those then are the general bases supporting the respondent's case that both the first instance judge, that is the Honourable Mr. Justice Leng, as he then was, and the Jamaican Court of Appeal correctly determined that this new 2017 action was an abuse of the process of the court. And in the case of the Court of Appeal, that it had no chance of success, that Mr. Finzi had no chance of success on an appeal. As you may find it useful, my lords, I point out for you those passages in both judgments that establish that the courts below did determine this 2017 action to be an abuse of the process of the court. The decision of the first instance court starts at page 135. The structure of this decision, as your lordships would have seen, is that it essentially, the first part of it deals with the case against the 7th and 8th defendants who are no longer part of this.
Yes.
And then it is a latter part of the decision that goes on to address the first, 5th, the second, 5th and 6th who are before you. So if you skip over the part dealing with the 7th and 8th, and if I take you directly to page 177, I would draw your attention, and of course I'm not going to read them unless your lordships wish me to, but I will just point out those paragraphs that I think establish that the court below did dismiss this action as an abuse of process. So you start at paragraph 99 there on page 177. The first line, going right up to issues previously raised by Mr. Finzi, basically saying that none of the components of fraud are new in the sense of not being founded on facts and issues previously raised by Mr. Finzi. Then if you go to paragraph 100, you see 4 lines from the top, this sentence starting with, this is because it is patently clear that Mr. Finzi had ample opportunity, straight down to Errol Campbell letter to which reference has already been made. And then on the next page, paragraph 101, and in relation to 101, you see that the particulars of fraud, the court mentions paragraph 86A to V, and why it mentions 86A to V of the particulars of claim is because that is where the so-called particulars of fraud are set out. But those so-called particulars of fraud all say that they are dependent on the information received from FinSAC, and that then is the new material. Not the letter from Eunice Goldfield in 2015 with the statements of account, but the letter received from Errol Campbell of FinSAC. And if you, the next passage I'd want you to have a look at is the words just below the quoted section in 102. And if I'm going too fast or you want me to read any of the sections, I will pause.
Well, I think the letter of 2015 is relied on in the pleading, and I'm hoping you will deal with it at some point. I'm sure you will.
Well, I'm going to address it, and my friend Mr. Manning will too. The court does find that armed with the information he received from Errol Campbell and the conclusions he asserts he drew from it, instead of entering into the settlement agreement, it was open to him to apply to amend the particulars of claim and elevate the claim to one along the lines of fraud, along the lines of the pleading in this case, but he did not do that. So that action wasn't even yet tried when he got that information, and he could have amended his pleading based on the information he received. The court is saying he didn't choose to do that. 104. Having entered into the settlement agreement, the parties, having acted on the settlement agreement and effecting the sale of Providence property by private treaty with the concurrence of Mr. Finzi and the surplus of US 2.1 million after the settlement of GF debt had been paid to him, it does not lie in Mr. Finzi's mouth to now allege a fraud which he could have pleaded before he entered into the settlement agreement. And so at paragraph 105, it wraps up to say, for those reasons, I find that the first, 5th, and 6th defendants have discharged their burden of proof and have satisfied the court that the claim against them is a breach of Henderson and Henderson abuse of process, which gives rise to a discretionary bar to these proceedings. And then if you go to the Court of Appeal reasons, I'll just highlight the aspects of that judgment that show
the first judgment.
The first judgment of the Court of Appeal at 200, page 200.
Yes.
The judgment that is the subject of this appeal. It is this judgment that is the subject of this appeal. Right. So I'm going to that judgment now. And I would ask your lordships to turn to page 206, just to show, first of all, at paragraph 13, the general test for the grant of leave to appeal is set out in paragraph 13. And if you flip the page and go to paragraph 16, you see that the Court of Appeal was reminding itself that it is important not to lose sight of the fact, and I'm at the last line of paragraph 16, that in considering this matter, we are here dealing not with a substantive appeal, but with an application for permission to appeal. And then if you go to paragraph 33 in that judgment, which is at 214, we'll see that the affidavit evidence put before the Court of Appeal alleged that the learned judge admitted and agreed there was a massive fraud. Suffice it to say in disposal of this point that a perusal of the judgment discloses no such finding. If I am correct in this observation, that removes the premise of ground H of the application and so disposes of that ground. And if you go to paragraph 37, which is a very material paragraph, and I'll spend a little more time on 37 with your permission. Before looking at the submissions, and that is on 215, before looking at the submissions in relation to reopening a case on the basis of newly discovered fraud and the applicability of the reasonable diligence condition, it may be useful to provide some background in respect of the circumstances in which the applicant became aware of information leading to discovery of what he contends to be the fraud perpetrated against him. That background is as follows. On 9 August 2011, the applicant received, pursuant to a request for information from the Financial Sector Adjustment Company, information that he requested on 8th of July 2011. More than a year after receipt of the information, that is on 28 August, he entered into a settlement agreement, previously mentioned, more than a year after receiving that information. The applicant, having been in breach of the terms of the settlement agreement, sued to enforce the agreement and obtain judgment by default. Pursuant to that judgment, the property was sold in 2015. The applicant's claim alleging fraud was not filed until 23 February 2017. That is 6 years after receiving the information from FinSAC and 2 years after receiving the net proceeds of sale of after the discharge of GRF's debt.
Ms. Barnard-Phillips, is the 2015 letter referred to anywhere in the judgment of the Court of Appeal?
I'm hesitant to answer that off the top of my head. When we come back, following the lunch break, I will.
Thank you.
But go to, if you would just, for the moment now, just go to the line above paragraph 40, which is on page 217.
Yes.
We'll see that the Court of Appeal is now addressing the submissions made on behalf of the 1st, 5th, and 6th respondents. And in that vein, if you look at the next page, at paragraph 42, you see about 5 lines from the bottom, the timeline set out in paragraph 25 of this judgment. Well, that 25 is a misprint, is a mistake, clearly. It should be a reference to paragraph 37 of this judgment, because that is where the timeline, the relevant timeline is set out. So they say the timeline in 37 is, in my view, sufficient to refute the contention that the learned judge erred in finding that the applicant had not done all he could have done to assert his claim of fraud before he entered into the settlement agreement of August 2012. And then you go to paragraph 44. In addition to the applicant's contention on the learned judge's application of the Henderson and Henderson principles, Mrs. Barnard-Phillips submitted that the facts of the present case fit squarely within the Henderson and Henderson principles, and that the learned judge was correct in applying those principles to the facts of this case. And then if you go to paragraph 47 on the next page, starting just with the quoted words above, which is the extract from the Venkatraman case. From the cases above, it is evident that the Henderson and Henderson rule may be engaged when the earlier proceedings concluded amicably.
I don't really understand what the discussion of Henderson and Henderson is about. It doesn't have anything to do with this, does it?
Well, except to say that Henderson and Henderson doesn't really apply if it is a case that you have an actionable case of fraud that you are now bringing. But if you have no actionable case of fraud and the material that was there before the court below.
Well, the only 2 points the Court of Appeal seemed to address are the reasonable diligence point, which you now accept as can't be sustained, and the Henderson and Henderson argument, which is irrelevant.
Well, the Henderson and Henderson, whether it is Henderson and Henderson or some other species, the point being made is that it was correctly determined to be an abuse of the process of the court. Well, it's either Henderson and Henderson or some other.
But is it an abuse? Even if there's no reasonable diligence condition, it might still be an abuse to seek to overturn a judgment alleging fraud when you knew about the fraud before that judgment was entered, because that is an oppressive duplication of the litigation.
Yes.
That could certainly be the case, but it's not what the Court of Appeal say as I read their judgment. They just say that these were allegations that could have been made in the earlier proceedings, Henderson and Henderson.
Yes, well, maybe the Henderson and Henderson reference is not strictly apposite, but to the extent that they're saying that there is an abuse of process, that is.
Well, that's what they're saying, but if it's for a wrong reason, then that's not very helpful to you.
Well, if it is, the question is it properly dismissed as an abuse of process of court, whether on Henderson basis or some other basis?
So they came to the right conclusion for the wrong reason?
They would have come to the right conclusion, even if it was for the wrong reason. And so, Millers, I would take you to now just a few general statements about the respondent's case. It is, I don't know if you want me to do it now, or, well, I can start now. Or you want me to come back?
Well, if you're starting a new topic, we'll rise now and we'll resume at 2 o'clock. Unless you want to use the remaining 3 minutes.
Could I just make a general statement in the remaining 3 minutes? So the first instance judge was correct, as was the Court of Appeal, in finding that the respondents discharged their burden of establishing that this case was an abuse of the process and that the appellant had no real chance of success on appeal. That was the right decision, whatever the reasons were. This brings the case within the area we say carved out inter car, which would allow a discretion to declare the case an abuse of process and to not allow it to go forward. So those are the 2 statements I wanted to make prior to coming back and picking up.
So you say that it falls within the express statement made by Lord Kerr in Takar, that it would be an abusive process in those circumstances.
Yes, but except that it may not fall exactly within the way Lord Kerr expressed it in Takar, but the general principle is that there are circumstances where, notwithstanding what is said in Takar, there is room for exercise, or there may be room, or there is room for the exercise of a discretion in certain circumstances, where it can be shown that the subsequent proceeding is truthfully an abuse of the process of the court.
Thank you. We'll rise now. We'll sit again at 2 o'clock. Thank you very much.